I'm glad that I had the opportunity to hear Deputy Naughton, a man whom I respect and whose knowledge of matters in this House is fairly extensive. But I have to say, with no disrespect to the point of view that you were expressing, when you resort to the minutiae detail of Supreme Court interpretations at a second stage debate, it would appear to me that many people on the other side of this debate recognise that the country has moved on in this matter and a rearguard action is being engaged upon. Last Count Corla, I welcome the publication of this bill before the House. As the second longest deputy serving in this House, I have for many years witnessed at first hand the division, pain and political reluctance to deal with the sensitive issue of abortion since the 8th Amendment to the Constitution was passed as far back as 1983. It has to be said that that referendum was an inspired political stunt to win the support of the so-called pro-life lobby during one of the most tumultuous periods of our democracy. Prior to the calling of the 1982 general election, the then Taoiseach, Mr Charles Haughey, had published the wording of an amendment to protect the life of the unborn that had been imposed upon him, so to speak, by the pro-life lobby. Immediately and sadly, Garret Fitzgerald endorsed it and promised a referendum on it in April of 1983. Last Count Corla, I have always been of the personal view that the wording in that amendment was flawed from the very outset. While it may have been an astute political tactic to win in votes in the elections, the wording of the amendment was anything but. Indeed, the pro-life lobby had become exercised by the jurisprudence of the Supreme Court in the 1970s, which they claimed had begun to find unenumerated rights, quote unquote, within the wording of the Constitution. The case which generated most concern in this regard was McGee versus the Attorney General, where the Supreme Court held that the imprescriptible rights of the family conferred a broad right upon spouses to privacy in marital affairs and, in effect, legalised the importation of contraceptives. The fear that the courts may introduce abortion rights through the back door was what led the pro-life campaign to amend the Constitution. The irony is that once they extracted a pledge from intimidated politicians to do just that, the wording of the 8th Amendment actually gave rise to the very situation which they sought to avoid. If we are to learn anything from this episode, it is that our Constitution is not something to be tampered with lightly. Indeed, I recall the Attorney General to the Fine Gael Labour coalition of that time, Mr Peter Sutherland, providing legal advice which said that the proposed wording would essentially pit the rights of the mother against the rights of the unborn child. In the event, under intense pressure from the pro-life lobby to deputies in this House, the alternative Sutherland wording was rejected. Yet that alternative wording was endowed with accuracy and foresight. The X case in 1992, to which many in the House have referred to already, shocked and appalled Ireland. It also led the Supreme Court to rule that the 8th Amendment meant the rights to life of the mother had to be balanced against the right to life of the unborn child. Ever since, we have known what the constitutional interpretation of Article 43(3) is. There is, of course, a right to life for the unborn child, but there is also a constitutional right for the mother to have her life protected. However, that right, a fundamental constitutional right, has never been vindicated in real and practical terms by this House, or these Houses. Instead, over many years, we've had to watch a steady stream of women travel to Britain to access abortion services to uphold their health. I hope that stream will be reduced somewhat by this legislation. Last Count Corla, I would like to put on the record of the House my personal appreciation and admiration to the 3 very brave women who took the ABC case against Ireland in the European Court of Human Rights in Strasbourg in recent years. I want to reflect for a moment on the different personal circumstances of these 3 women, because they are sad examples where, in the 21st century that is Ireland, the human rights of women to have an abortion here may have been accepted in theory, but were actually denied in practice. They are very good examples as to why we need this legislation. The first applicant was unmarried, unemployed, and living in poverty. She became pregnant unintentionally, believing that her partner was infertile. She had 4 children, all at that time in foster care as a result of problems the applicant had experienced as an alcoholic. During the year preceding her 5th pregnancy, the applicant had remained sober and had been in constant contact with social workers with a view to regaining custody of her children. She considered that a further child at this critical moment in her life would jeopardise the successful reunification of her existing family. She decided to travel to Britain to have an abortion. The UK's National Health Service refused to carry out the operation at public expense, and she had to borrow money for treatment in a private clinic from a moneylender. Her difficulty in raising the money delayed the abortion by 3 weeks. She had to travel to England alone, in secrecy, and with no money to spare, without alerting the social workers and without missing a contact visit with her children. On her return to Ireland, she experienced pain, nausea and bleeding for 8 to 9 weeks, but was afraid to seek medical advice because of the prohibition on abortion. Lascancora, the second applicant, was single when she became pregnant unintentionally. She was advised by 2 different doctors that there was a substantial risk that it would be an ectopic pregnancy, where the fetus develops outside the uterus. The applicant was not prepared either to become a single parent or to run the risks associated with an ectopic pregnancy. She travelled to England for an abortion. On her return to Ireland, she started passing blood clots, and since she was unsure whether or not this was normal and could not seek medical advice in Ireland, she returned to the clinic in England 2 weeks after the abortion for a checkup. The impossibility for her to have an abortion in Ireland made the procedure unnecessarily expensive, complicated, and highly traumatic. For 3 years, the third applicant was treated with chemotherapy for cancer. The cancer went into remission, and the applicant unintentionally became pregnant. When she discovered she was pregnant, she was unable to find a doctor willing to make a determination as to whether her life, not her health, whether her life would be at risk if she continued to term, or to give her clear advice as to how the fetus might have been affected by the tests which she had undergone. Given the uncertainty about the risks involved, the third applicant decided also to have an abortion in Great Britain. Lascancora, these cases are all incredibly sad, but also damning indictments of our reluctance as a country to legislate for so long to introduce the X case. For too long, our democracy has been cowed into fear and submission by those vested interests to not legislate for the constitutional rights of pregnant women to have their lives protected in a medical emergency. I welcome very much the fact that we are, for the first time ever, dealing with this issue in a way that might make some of these cases a thing of the past. I'm impressed by the reasoned and mature contributions from deputies on all sides of the House. I welcome that this Parliament is dealing with this matter not on strictly party lines, but as legislators with one common goal: to ensure the constitutional rights of women in Ireland are upheld and vindicated. And in doing so, we have to have regard to the judgment of the Supreme Court in its entirety. For over 20 years, successive governments have dodged this issue. I'm proud as a Labour TD, as a Social Democrat, as a feminist and as a father, to be at last speaking on this bill. We have waited so long. I believe it will give women access to the rights that they are entitled to, by the Constitution of this Republic. But Lascancora, in my view, I would like us to be able to go further. We should be able to legislate for abortion in the cases of the health of a woman, fatal fetal abnormalities and other reasons as well. In essence, I believe it is the woman's right to choose, and that we, especially men, should both respect and support their decisions. Because many hold the view that our Constitution today does not allow us to go beyond what this bill proposes, but this is what we are doing. But that is no reason why it should not be supported. The best should not drive out the good, so to speak. Finally, this bill, when enacted, will still not be compulsory. People who abhor abortion in any form whatsoever will not be compelled to avail of its provisions. But could I conclude, Elas Ceann by saying 97 years ago in this city, proclamation of the Republic proclaimed a new kind of Ireland, proudly. In a republic, different faiths and moral points of view should both be heard and respected. But no faith, however dominant and however sincerely held by those who profess it, should be allowed to prevail over the wishes of minorities of citizens, particularly when it's intended to enshrine those beliefs into law. Once upon a time, Elas Ceann, the dominant church in this country held the view that it could impose its belief system into the law of this land in the name of the Republic. That day is over, and the enactment of this legislation will ensure that we arrive to the point where women in the Republic of Ireland do have the right to choose.